Have you ever felt overwhelmed by debt collectors hounding you for money you're not even sure you owe, especially as a senior living on a fixed income? If you're over 60 and struggling to keep your head above water, this video is your lifeline. I'm Sharon, a lawyer who's helped hundreds of seniors navigate the stress of debt, financial pressure, and aggressive collection tactics. Today, I'm revealing 6 surprising debts you might legally walk away from. Debts that could be costing you thousands unnecessarily. Some of these will shock you, and knowing them could save you from years of stress and financial strain. Stay with me until the end to discover how to protect your peace of mind and keep your hard-earned money where it belongs, in your pocket. Before we begin, I would appreciate it if you like this video. You can help me continue to spread the old age lesson. If you haven't subscribed yet, I recommend you subscribe and turn on the bell so you don't miss any videos. If you like this video, please comment number 1. If you don't like it, comment number 0 to let me know, so I can make a better video for you. Now let's get started. 1. Old credit card debt beyond the statute of limitations. One of the most insidious financial traps that seniors encounter is old credit card debt that has surpassed the statute of limitations. This issue is pervasive, and understanding it thoroughly can save you from unnecessary stress and financial loss. Let's paint a vivid picture. Imagine it's the early 2000s, and you had a credit card with a lingering balance. Perhaps $2,000 or $5,000. Life took a challenging turn. Maybe you faced a sudden medical emergency, lost a job, or were overwhelmed by mounting interest rates and fees that made the balance balloon. For whatever reason, the payment stopped, and the account went into default. Years passed, 10, 15, or even 20, and you assumed the matter was closed, a relic of a difficult chapter in your life. Then, out of the blue, your phone rings. It's a debt collector, claiming you owe thousands, including accrued interest and fees. They might threaten legal action, wage garnishment, or even imply they can seize your Social Security benefits, which, by the way, is almost always a hollow threat since federal law protects Social Security benefits from most debt collection efforts. Here's the critical information debt collectors hope you don't know. Every state and territory in the United States has a statute of limitations on debts, a legal time limit during which a creditor can sue you to enforce payment. Once this period expires, the debt becomes time-barred, meaning the creditor or collector loses the legal right to take you to court to enforce the debt. The length of the statute of limitations varies by jurisdiction and debt type. For credit card debt, which is typically classified as an open-ended account, the time limit ranges from 3 to 6 years in most states, though some states, like Kentucky, allow up to 15 years for certain written contracts. For example, in California, the statute of limitations for credit card debt is 4 years, while in Texas, it's also 4 years, but in Ohio, it's 6 years. You can find your state's specific statute of limitations by checking with your state's Attorney General or Consumer Protection Agency. What does time-barred mean in practical terms? While the debt may still technically exist as a moral or accounting obligation, the creditor can no longer obtain a court judgment to force repayment through measures like wage garnishment or bank account levies. However, debt collectors often rely on intimidation, hoping you're unaware of your rights. Here's where the situation gets tricky. Certain actions on your part can inadvertently reset the statute of limitations, giving collectors a fresh window to pursue legal action. For instance, making even a small payment, say $10 to show good faith, or verbally acknowledging the debt as yours during a phone call can restart the clock in many states. Debt collectors are trained to exploit this. They might use friendly language, saying, "Can you just send us something to keep this account active?" Or, "Don't you want to settle this old matter?" These tactics are designed to trick you into reviving a legally unenforceable debt. So, how should you handle a call about an old credit card debt? Follow these steps to protect yourself. Do not admit or acknowledge the debt. Avoid saying anything that could be interpreted as accepting responsibility, such as, "I know I owe this," or "I'll try to pay something." Instead, remain neutral and say, "I need more information about this matter." Request written validation. Under the Fair Debt Collection Practices Act, FDCPA, you have the right to demand that the collector provide a written debt validation notice within 5 days of their initial contact. This notice must include the original creditor's name, the amount owed, and your right to dispute the debt. Politely say, "Please send me all details in writing. I will not discuss this over the phone." Verify the debt's age. Determine when the debt was last active, Typically, the statute of limitations starts from the date of your last payment or the date the account went into default. Check your records or request a credit report from agencies like Equifax, Experian, or TransUnion to confirm the timeline. If the debt is beyond your state's statute of limitations, it's legally unenforceable. Send a cease communication letter. If the debt is time-barred, you can write a letter to the collector stating that the debt is outside the statute of limitations and demanding that they stop contacting you. Under the FDCPA, they must comply. Keep a copy of the letter and send it via certified mail for proof. Know your rights. If the collector continues to harass you or threatens illegal actions, e.g., garnishing Social Security benefits, file a complaint with the Consumer Financial Protection Bureau, CFPB, at consumerfinance.gov or your state's Consumer Protection Agency. By understanding the statute of limitations and exercising your rights, you can free yourself from the burden of old credit card debt. You're not obligated to pay a debt that's legally expired, and you deserve to live without the fear of predatory collection tactics. If you are still watching this video and finding these lessons useful, please comment number 1 below to let me know that you are still watching this video with me. Thank you for your valuable time. 2. Medical debt written off by providers. Medical debt is one of the most emotionally and financially crippling burdens for seniors, especially those on fixed incomes like pensions or Social Security. Imagine this scenario. You undergo a critical procedure, perhaps heart surgery or a hip replacement, that saves your life or improves your quality of living. Weeks or months later, the bills start arriving. $2,000 for lab tests, $5,000 for the hospital stay, $1,500 for anesthesia, and another $1,000 for follow-up visits. Even with Medicare or private insurance, the out-of-pocket costs can be staggering. If you can't pay, the provider may send the debt to a collection agency, and suddenly, you're receiving aggressive calls demanding payment for amounts you can barely comprehend. Here's a lesser-known fact that can change the game. When hospitals, clinics, or doctors' offices deem a medical debt uncollectible, they often charge it off as a business loss for tax purposes. This means they've written off the debt on their books, often selling it to a third-party debt collection agency for a fraction of its original value, sometimes as little as 10 cents on the dollar. Once the debt is sold, the collector tries to recover as much as possible, often using high-pressure tactics. But here's the key. You don't owe the debt collector anything unless they can prove you legally owe the debt. Under the FDCPA, collectors must provide a debt validation notice proving the debt's validity, including documentation that ties the debt to you and verifies the amount. In many cases, especially with older medical debts, collectors lack this documentation because records are incomplete or lost during the transfer from the provider to the agency. Moreover, medical debts can also become time-barred under the statute of limitations, just like credit card debt. The timeline varies by state, typically 3 to 6 years for medical debt, so it's crucial to check when the debt originated. If it's beyond the statute of limitations, the collector cannot sue you to enforce payment. Another critical but often overlooked fact. Many hospitals, particularly non-profit ones, are legally required to offer financial assistance programs or charity care to low-income patients, including seniors. These programs can significantly reduce or eliminate medical bills, but hospitals rarely advertise them. For example, a non-profit hospital might have a policy to forgive 100% of bills for patients with incomes below 200% of the federal poverty level, yet you might never hear about it unless you ask. Here's how to handle medical debt collectors and protect your financial well-being. Request debt validation. When a collector contacts you, immediately ask for a written debt validation notice. This should include the original provider's name, the date of service, the amount owed, and proof that you owe the debt. Without this, they have no legal standing to collect. Check the debt's age. Determine when the medical service was provided or when the last payment was made. If the debt is past your state's statute of limitations, inform the collector in writing that it's time-barred and demand that they cease contact. Inquire about financial assistance. Contact the original healthcare provider, hospital, or clinic to ask about their financial assistance or charity care programs. Many hospitals have online applications or dedicated financial counselors. Provide proof of your income, e.g., Social Security statements or tax returns, to qualify for relief. Negotiate or dispute errors. If the debt is valid and within the statute of limitations, check for billing errors, which are common in medical bills. You can also negotiate a lower payoff amount, especially if the debt was sold to a collector for pennies on the dollar. Offer a lump sum you can afford, but get any agreement in writing before paying. Seek legal help if needed. If collectors use illegal tactics, e.g., harassment or false threats, consult a consumer attorney or report them to the CFPB. Organizations like Legal Aid or AARP's Legal Services Network can offer free or low-cost assistance to seniors. Medical debt can feel overwhelming, but much of it rests on shaky legal ground. By asserting your rights and exploring assistance options, you can often reduce or eliminate these debts, freeing yourself from undue stress. 3. Debt solely in a deceased spouse's name. The loss of a spouse is one of life's most devastating experiences, and predatory debt collectors often exploit this vulnerability to pressure seniors into paying debts they don't legally owe. Picture this: you're grieving the passing of your husband or wife, grappling with emotional and financial upheaval. Amid this turmoil, a debt collector calls, claiming your spouse left behind a $10,000 credit card balance or an unpaid loan. They might say, "This is your responsibility now," or "Paying this debt honors your spouse's memory." They may even threaten to damage your credit or pursue legal action if you don't comply. These tactics are not only heartless but also often illegal. Let's be unequivocally clear: if a debt was solely in your deceased spouse's name, meaning you did not co-sign the loan, jointly apply for the credit card, or otherwise agree to be responsible, you are not legally obligated to pay it from your personal income, savings, or pension. Creditors and collectors can only seek repayment from your spouse's estate, which includes assets like savings accounts, real estate, or other property they owned at the time of death. Even then, estate debts are paid according to state probate laws, which prioritize certain debts, e.g., funeral expenses or taxes, over others. If the estate has no assets, creditors may be out of luck. Unfortunately, collectors prey on grieving seniors, banking on their emotional vulnerability or lack of legal knowledge. They may imply that you're morally obligated to pay or falsely claim that your credit will be ruined if you don't. In reality, a debt in your spouse's name alone does not affect your credit score unless you were a co-signer or the debt was tied to a joint account. Here's how to protect yourself when dealing with collectors pursuing a deceased spouse's debt. Confirm the debt's ownership. Ask the collector to verify whether the debt was solely in your spouse's name or if it was a joint account. Request a copy of the original credit agreement or loan documents. If you didn't sign the agreement, you're not responsible. Direct collectors to the estate. Inform the collector, preferably in writing, that the debt belongs to your spouse's estate and that they must pursue repayment through the estate's executor or administrator. For example, say, "This debt was in my spouse's name only. You must contact the estate's executor. Do not contact me again." Send a cease communication letter. If the collector persists, send a written letter via certified mail demanding that they stop contacting you. Under the FDCPA, they must comply. Keep records of all communications for evidence. Understand community property states. If you live in a community property state, e.g., Arizona, California, Texas, or Washington, debts incurred during marriage may be considered shared, even if only one spouse's name is on the account. However, this applies only to debts incurred during the marriage, and collectors must still prove their claim through the estate. Consult a probate attorney if you're in a community property state. Report illegal tactics. If collectors harass you, threaten you, or misrepresent your liability, file a complaint with the CFPB or your state's attorney general. You can also seek help from organizations like Legal Aid or AARP for free or low-cost legal advice. Protect your credit. Check your credit report to ensure the debt isn't erroneously reported as yours. If it appears, dispute it with the credit bureaus, Equifax, Experian, TransUnion, and provide documentation showing it belongs to your spouse's estate. Grieving a spouse is hard enough without the added burden of predatory debt collectors. You are not legally or morally obligated to pay debts that aren't yours, and you have the right to stop harassment. By knowing your rights and taking decisive action, you can focus on healing rather than fighting unjust financial demands. If you are still watching this video and finding these lessons useful, please comment number 2 below to let me know that you are still watching this video with me. Thank you for your valuable time. 4. Federal student loans, including Parent Plus loans, after disability or death. For many seniors, the burden of federal student loans is an unexpected and heavy weight carried into retirement. These loans often originate from well-intentioned decisions made years earlier, Perhaps in your 40s or 50s when you took out Parent Plus loans to finance your child's college education, or maybe you pursued a degree yourself later in life to advance your career or fulfill a personal goal. With tuition costs soaring, these loans can balloon into significant debt, leaving you in your 60s, 70s, or even older, grappling with monthly payments on a fixed retirement income such as Social Security or a modest pension. What many seniors don't realize is that federal student loans come with a critical lifeline. They can be fully discharged under specific circumstances, such as total and permanent disability, TPD, or death. This applies to a wide range of federal loan types, including direct subsidized and unsubsidized loans, Parent Plus loans, Graduate Plus loans, and federal consolidation loans. If you, as the borrower, become totally and permanently disabled, meaning you can no longer work or engage in substantial gainful activity due to a physical or mental impairment, you may qualify for a TPD discharge. Additionally, if you took out a Parent Plus loan to fund your child's education and that child passes away, the loan can also be discharged. Perhaps most reassuringly, if you, the borrower, pass away, your federal student loans are not passed on to your family or estate. They are canceled entirely, ensuring your loved ones are not burdened with your debt. However, navigating this process is not always straightforward, and many seniors are unaware of these options due to a lack of clear communication from loan servicers. For instance, you don't necessarily need to be receiving Social Security Disability Insurance, SSDI, to qualify for a TPD discharge. Other forms of documentation, such as a physician's certification attesting to your disability or verification from the Department of Veterans Affairs, VA, for service-connected disabilities, can also suffice. Unfortunately, some loan servicers fail to inform borrowers of these rights or make the application process unnecessarily complex, leaving many eligible seniors stuck with payments they may not legally owe. If you believe you qualify, here's what you need to do. Contact your loan servicer and inquire about the Total and Permanent Disability, TPD, discharge program. Request detailed information about the application process and the specific documentation required, which may include medical records, a physician's statement, or proof of SSDI or VA benefits. Submitting a complete and accurate application is critical, as the process is not automatic. Once approved, your federal student loan balance will be wiped out, providing significant financial relief and allowing you to focus on enjoying your retirement without the stress of ongoing debt payments. 5. Debt forgiven in bankruptcy but still being pursued by collectors. Bankruptcy can be a lifeline for seniors struggling with overwhelming debt, offering a fresh start by legally eliminating certain financial obligations. For older adults, Chapter 7 bankruptcy is particularly common, as it allows for the discharge of unsecured debts, those not tied to collateral, such as credit card balances, personal loans, medical bills, utility bills, or past due rent. Once a bankruptcy court grants a discharge, these debts are legally erased, meaning you are no longer obligated to pay them. This process is designed to provide relief and help you regain financial stability. However, a disturbing issue arises when unscrupulous debt collectors attempt to collect on debts that have already been discharged in bankruptcy. These collectors may call, send threatening letters, or use other aggressive tactics, hoping to exploit your confusion or lack of knowledge about your legal rights. This behavior is not only unethical but also illegal. Once a debt is discharged, it ceases to exist in a legal sense, and collectors are prohibited from contacting you about it under the Bankruptcy Code's discharge injunction. Violations of this injunction are serious and can result in penalties for the collector, including potential lawsuits or fines. Unfortunately, many seniors fall victim to these tactics, mistakenly believing that the collector's persistence means they still owe the debt. Some may think, if they're calling, they must have a valid claim, or maybe I misunderstood the bankruptcy process. Collectors rely on this uncertainty to pressure you into paying debts you are no longer responsible for. To protect yourself, take these steps. First, review your bankruptcy paperwork to confirm that the debt in question was included in the discharge. If it was, contact the collector, preferably in writing, and inform them that the debt was discharged in bankruptcy, citing your case number and the date of the discharge. Clearly state that their attempts to collect are a violation of federal law. If the harassment continues, report the collector to your bankruptcy attorney, the Federal Trade Commission, FTC, or the Consumer Financial Protection Bureau, CFPB. In some cases, you may have grounds to take legal action against the collector for violating the discharge injunction. The bankruptcy process is grueling, and you've already taken the courageous step of seeking a fresh start. Don't let predatory collectors undermine your hard-won financial freedom by dragging you back into debts that no longer exist. If you are still watching this video and finding these lessons useful, please comment number 3 below to let me know that you are still watching this video with me. Thank you for your valuable time. 6. Small balances that cost more to collect than they're worth. Small debts, those typically under $100 or, in some cases, up to $500, can cause disproportionate stress for seniors, particularly when debt collectors begin pursuing them. These debts often stem from minor oversights, such as an unpaid utility bill from a previous residence, a cell phone cancellation fee, a forgotten gym membership from years ago, or a medical copay that was never properly billed. While these amounts may seem trivial, they can lead to persistent calls, letters, or threats from collectors, leaving you worried about legal action, wage garnishment, or damage to your financial security. The reality is that debt collectors operate on a cost-benefit analysis. Pursuing small debts often costs more in time, resources, and legal fees than the debt itself is worth. For example, taking a $74 debt to court involves filing fees, attorney costs, and administrative expenses that far exceed the amount owed. As a result, collectors are unlikely to sue over these small balances. Instead, they may rely on intimidation tactics, hoping you'll pay to make the issue go away. In many cases, if the debt remains unpaid, collectors may sell it to another agency or eventually write it off as uncollectible. For seniors living on fixed incomes, receiving a collection notice for a small debt can trigger significant anxiety. Many fear that even a minor balance could escalate into a lawsuit or threaten their Social Security, pension, or other retirement funds. However, most small debts don't warrant such aggressive action, and certain income sources, like Social Security, are generally protected from creditors. If you're being contacted about a small debt, take a moment to assess the situation. Verify the debt's legitimacy, check whether it's within the statute of limitations, the time period during which a collector can legally sue, and consider negotiating a settlement if the debt is valid and you're able to pay. If the debt is old or questionable, you can dispute it with the collector and request validation. In many cases, collectors will back off when faced with resistance or when the cost of pursuit outweighs the potential recovery. By understanding the economics of debt collection, you can approach these situations with confidence, knowing that many small debts are unlikely to result in serious consequences. Focus on protecting your financial well-being, and don't let collectors exploit your concerns over minor balances. That's it for today's video, folks. I hope you found these insights about the 6 debts seniors can legally walk away from eye-opening and empowering. Take a moment to reflect. What's one thing you've learned today that surprised you or that you're ready to put into action to protect your financial peace? Maybe it's checking the statute of limitations on an old debt, requesting validation for a medical bill, or standing firm against collectors for a debt that isn't yours. Drop a comment below this video and share that one key takeaway you'll bring to practice in your life. I'd love to hear from you. If you found this video helpful, please leave your comment below, and don't forget to like, share, and subscribe to our YouTube channel for more tips to take control of your financial future. Stay empowered, and I'll see you in the next video.